Hi, I'm Mark Hanna with the Insurance Council of Texas, and with me today is Jay Thompson, partner in the law firm of Thompson Coe, Cousins and Irons. House Bill 1774. It passed through the legislature. It has been signed by Governor Abbott. And Jay, you got to feel good that this legislation passed. It didn't last session, but it got through this session and took a lot of hard work.
Yes, it did. I think the TLR did a great job on this, and I think it's really going to be a good bill, particularly for consumers, because I think it maintains any cause of action that they already have. Those were not changed. What it does is require notice to a company before suit, requires them to specify exactly what it is a company didn't pay that they think they should have paid, and the attorney has to give a reasonable number of attorney's fees spent in preparing that notice. We've seen a lot of abuses where you've just seen companies, they get sued with no notice. The specifics about the claim on why they owe more money is not provided till mediation. The demand for attorney's fees is often very excessive. One example, Texas Supreme Court case, I saw a case where the jury awarded $20,000 for a roof loss after Hurricane Ike. The demand when the suit was filed was over $600,000. The trial court found that to be an excessive demand for both attorney's fees and other items. I think this bill will cure that type of model, and that's also going to protect consumers because hopefully, if they do have a claim, it's going to get resolved quicker in the process. And if they have to hire a lawyer, they can do that. And if they make reasonable demands, if the company is unreasonable, the attorney will be able to recover his fees.
Is this going to be the answer to all of the issues that were raised over the past 5 years with all the thousands of lawsuits that we've seen?
Well, I don't think it'll be the total answer, but I think it will cure a lot of the abuses that we saw, and I think if the courts apply this fairly, I think the consumer will be better off. We also saw cases where there were lawsuits filed where some consumers didn't even know they were represented by a lawyer. And one of the things the bill does is the lawyer has to send the notice not only to the insurance company before suit, but they have to send that to their client. That's a very good consumer protection.
And it's also got to have merit. It can't just be, well, let's just file a lawsuit and see if we can get some extra money.
I think that's right. I mean, repair costs can be sometimes difficult to estimate, but I think this will rein in costs, especially after a hail event. Hail often damages a roof of a home. It may not damage items inside the home unless there was some penetration to the roof.
The bill takes effect September 1. In the meantime, it gives lawyers 3 more months to file lawsuits, and we may see a lot of activity coming out of the San Antonio storm last year, which is the costliest hailstorm in Texas history. Any way that this legislation passing but not taking effect until September 1 can affect any of that litigation?
Well, it may have some indirect effect in the way courts may apply existing law. There's some common law doctrines against excessive demands. There's also requirements to enforce contracts where companies send a case to appraisal, go to appraisal, and pay an appraisal award. And most courts will go ahead and grant summary judgment after that is done. I think that to the extent that that's already in the law, I think courts will be more inclined to stop some of the abusive practices using current law in light of the fact that the new law, even though it won't apply, in light of the fact that the legislature has attempted to address what they refer to as abusive practices.
Thank you. Jay Thompson.